Sri K. N. Balagopal.
Sir, I raise to support this bill. Sir, this bill, the amendments in three bills is for helping the common investors of this country. Sir, by this amendment, through this amendment, I hope that the regulator, SEBI, will go into the details of many of the frauds happening in the country in the name of share market. But sir, some of the provisions, which like other honorable members said here, may lead to some arbitrariness that I also fear. Sir, but at the name of that arbitrariness, we cannot say that such a strengthening of the provisions is not necessary. Sir, we are hearing a lot of cases from Harshad Mehta onwards. And now, in the yesterday newspapers, I read a story about a video conferencing facility in Tihar Jail to discuss with the other countries. One of the biggest investors in the country, one of the biggest investment banks in the country, the owner is in Tihar Jail, and he is trying to sell 20 crores property to give back the debt to the people, and for that the Honorable Supreme Court or High Court arranged a video conferencing facility in the jail. So this is a rare occasion, sir. Such a person was booked because of some continuous struggle by some of the SEBI officers and others. But generally these people are not coming under the law, and they are not coming to this kind of difficulties. Sir, now we are reading some stories about the huge loan taken by Bhushan Steel. Around 40 crore rupees was taken by a company in the country. Even State Bank of India and other banks were given that loan, and it is much more than their net worth. So this much money is going. Then another case of IDBI is coming about Kingfisher. After the Kingfisher went into trouble, 1,000 crores was given. So these kind of stories are coming. So SEBI and other regulators should be strengthened. So I also accept that point. But sir, while going to the provisions, like first clause in this bill, clause 2 and 1A, which is calling for information and records from any person, including any bank like that. There, the investigation can be like a fishing expedition. When investigation regarding the matters of companies affairs, one of the famous case, Minerva Mills case, the court said, Supreme Court said that the investigation means it should not be a fishing expedition. So proper care should be there. Proper care should be there. The arbitrary attitude of the officers may create problem. And then 1B is there, sir. That retrospective effect from 1998 onwards. This particular amendment provision will be effective from 1998 onwards. I don't know what is the basic need for that 1998 provision. So if the minister, while replying, if your minister is clarifying, it will be very good. 1998 onwards, this retrospective effect is given, and now the GAR Act, which we already passed, the government is not willing to, that is a tax matter, I know the difference, but why this retrospective? I am not against that, but proper clarification should be given about that retrospective effect. Then, sir, about clause 3, that is subsection 1(3). Involving a corpus amount of 100 crore rupees or more shall be deemed to be a collective investment scheme. Here, a collective investment scheme, 100 crore is needed. So those which are collecting or collective investment scheme which is less than 100 crore will not come under the purview of this act. I think it should be less. Sharda Chitti Fund is it is not directly coming, but many funds may be there. Those funds which is collecting more than 100 crore will only come under the purview is not a good aspect. So it should be reduced, and it should be effective for other companies. Sir, while coming about the designated courts aspect, Nareshji also already spoke here. Designated court. Designated court can be there in every state. That is a good suggestion. Why only in Mumbai? Yes, SEBI is in head office in Mumbai, registered office in Mumbai. That logic is there, but every state can be. No, I think SEBI by this Mumbai, I don't know, but That designated court, I know, special court is there, provision is there under the High Court. Every High Court is the appellate body, that is separately coming. I am saying about the search, the notice for search, the designated court is only in Bombay. So only in Bombay for search orders, that can be in, because I am also supporting the argument by, put forth by Mr. Naresh ji, it can be in states also. Sir, another important provision which needs the, I think, generally this act is very strong, but the weakness of the amendment is coming when we are looking into the matter related to the penalties. Sir, penalties, earlier all acts had a very strong provision for penalties, and penalties were not properly affected. I don't know all the cases, but penalties provision were there. Here, sir, at least some 20 places, the amendment is there, and a very strong amendment provision is also given. The amendment is also separately given by Mr. Rajiv Chandrasekhar here. That is also concerned about this. Sir, earlier the provision in many of the aspects, I will see clause, I'll say clause 6. This is about a fine, which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupee for each day during which such failure continues, subject to a maximum of 1 crore. Each day 1 lakh rupee provision was not there. Now it is like an electricity bill. If I am failing to pay electricity bill on the day, I can give it with fine. If a big company gives 1 lakh rupee per day, means up to 100 days he can make a failure. Sir, this is an important aspect. Not only this, sir. Then there is a fine about insider trading. That is clause 12, 15G. Earlier 15G, sir, please give me 1 minute. This is only 6 minutes, sir. See, insider trading is in US. We are following many of the company activities, corporate area, we are saying that US laws are very good. But in corporate law, if it is in US, insider trading is a very good reason for banning the company from this, from the listing and seizure of document, everything is there. Sir, insider trading, earlier it was a huge fine. Okay. Now it is also reduced. So, fine part, regarding the fine part, penalty part, this amendment is loosened earlier. It is not strict, and it is very liberal aspect is there. So that is to be looked into, and the strong punishment should be there for violators.
Okay, thank you.